Thank you so much. I appreciate it. And I will say this. I know we have a full house today, and I appreciate everybody joining. I think we have a full house because this law and the way it was implemented by the government was disjointed. So we're going to do the best we can. We will have a question and answer period at the end after about an hour and 15 minutes. And please feel free to email questions as well. If I can't get to any question, I'd be happy to get to all questions within the next day or so. So if it's okay with you, Joe, I'm just going to start. Okay, so you should know that the interim final rule to the No Surprise Act was released recently on September 30th. And those that are involved in out-of-network revenue cycle like myself, we were hoping that this interim final rule would provide some answers. But unfortunately, it's led to more questions. But we're going to go through it, and then we're going to go through the various provisions. And hopefully by the end of this presentation, you'll have a much better understanding of this very important law. So the interim final rule, the IFR, they're focused on three areas: required notices and disclosures for out-of-network providers, required steps for balanced billing of patients. That means when you can balance bill and when you can't balance bill, and good faith estimates. Interesting thing about good faith estimates, as we'll talk later, it only applies at this point to uninsured or self-pay patients, not for those that use their insurance. Like I said, many questions. Because there's so many questions, there's multiple lawsuits that were filed as a result. The end result is we're kind of in limbo in a lot of the provisions, particularly those relating to arbitration. But I'll go into all of that. Okay, so we're going to briefly go through the rules. Okay, what I want you to understand though is keep this in mind: the purpose of the act. Once if you have a question, go back to the purpose of the act. The act is designed to avoid surprise medical bills being sent to patients on an out-of-network basis. All right, so we've all had situations. I personally had a situation when I went in for surgery and did not know that the anesthesiologist was out of network, and then I got a $10,000 bill. The act is designed to avoid that type of situation. So if you understand the purpose to avoid surprise medical bills, all right, then you'll understand the rules. So first rule number one, emergency services. All right, you cannot balance bill patients for emergency services. You can only bill the patient the in-network cost share. And if there's a dispute with the insurance company, their IDR, which is the arbitration process, is available. And again, that makes sense, right? A patient can't consent to waive the protections under the act in an emergency situation when the patient is being wheeled in with a gurney to the emergency room. So I think that makes a heck of a lot of sense. Okay, let's talk about the situation of non-emergency services. Here's the thing that most providers that I speak to in revenue cycle people don't really understand. The balance bill notice requirements, or the ability of a patient to waive the protections under the act so that you can balance bill, that only applies for non-emergency out-of-network services at an in-network facility. Does not apply for the scenario of an out-of-network doctor going to an out-of-network ambulatory surgery center or an out-of-network hospital. All right, so what I'm going to discuss right now does not apply to that scenario. Out-of-network surgeon going to an out-of-network ambulatory surgery center. This is only dealing with non-emergency services, out-of-network surgeon or provider going to an in-network facility, like an in-network ambulatory surgery center or a hospital. Okay, So if you don't, in that scenario, if you don't get a notice and consent signed by the patient, where the patient acknowledges that they're going to an out-of-network facility, then it gets treated like an emergency service. If the patient doesn't waive the protections under the Act, then you cannot balance bill the patient. You can only bill the patient in-network cost share. And if there's a dispute between carrier and provider, then you can certainly go to our IDR, which is the arbitration proceeding. So I think that makes sense too. If the patient doesn't consent to waive the protections under the Act, then that patient cannot be billed more than their in-network cost share. You cannot balance bill that patient. But what if in the same scenario, you get the notice and consent signed, where the patient acknowledges they're going to an out-of-network provider, that their cost share will be higher, and they sign and date a consent form and the prescribed form, which we'll talk about. In that scenario, you can balance bill the patient, except if you're an ancillary service provider, and we'll talk about that. And you'll understand ancillary service provider if you, again, keep thinking about the purpose of the Act to avoid surprise medical bills. If the patient is signing a consent, it's not a surprise bill. So you can certainly balance bill the patient. If you're going to balance bill the patient, you're not, if there's a dispute, you can't go to IDR. You can't go to arbitration. Okay, so that's the scenario. That's a second scenario for non-emergency out-of-network services at an in-network facility. Okay, let's talk about ancillary services. If you're an ancillary service provider, you're treated the same way as an emergency service. The patient cannot waive the protections under the Act. And you'll see that makes a lot of sense, because ancillary providers are considered emergency medicine. Anesthesiologists, the situation that I spoke about earlier, right? Anesthesiologists in a situation where a surgeon goes to an in-network facility and the patient, unbeknownst to them, gets treated by an out-of-network anesthesiologist, that patient, traditionally would get a surprise bill and be upset like I was, all right? Anesthesiologist is considered an ancillary service provider, all right? It's per se ancillary service. That means you cannot balance bill the patient. Patient is only responsible for in-network cost share, and IDR is available if you're an ancillary provider. So look at the type of ancillary service providers: emergency medicine, anesthesiologists, pathology, radiology, neonatology, assistant surgeons, hospitalists, intensivists, radiology services, laboratory services. All right, this all makes sense, right? Again, avoid surprise medical bills. So if you're an ancillary service provider, you cannot balance bill the patient. The patient is only responsible for in-network cost share. The patient cannot waive the protections under the Act. And if there's a dispute with the carrier, you can go to arbitration. So if the patient knowingly waives the protections under the No Surprise Act with the notice and consent form that's prescribed by CMS, you can balance bill the patient unless it's emergency services or we're dealing with an ancillary provider. Okay. Again, the notice and consent forms must be those prescribed by the department, the CMS, and that includes in those consent forms, there's a good faith estimate requirement, which we'll talk about, which is that component of the law was all screwed up the way it was implemented. So, enforcement of the good faith estimate requirement is probably not going to happen until 2023, except for uninsured and self-pay patients. So a lot of people are freaking out about the good faith estimate requirement. I don't know how the carriers and the providers are going to come up with a workable workflow for that. And that's why I've been told there's going to be no enforcement. If you don't get a good faith estimate, no enforcement until 2023. So that's good news. Again, good faith estimates are required for only uninsured patients or insured patients that decide not to use their insurance coverage. So they're essentially self-pay. In those scenarios, a good faith estimate is required. And in the most common scenario where you're submitting insurance, good faith estimates are required, but they're not going to be enforced. Non-compliance is not going to be enforced until 2023. Again, I just want to highlight that the No Surprise Act does not apply to out-of-network services at an out-of-network facility. Okay, some other rules that you should be aware of. Non-compliance. There's huge and hefty penalties, up to $10,000 penalty per violation. That's for balance billing a patient in violation of the No Surprise Act. So those are big penalties, and that's why we have such a high number of people at this presentation. You need to know this, because if you don't know these regulations, you can get yourself into trouble. All right, now here's some things about the IDR process. And by the way, just as from a practical standpoint, I do revenue cycle. I'm also an attorney, so I'm involved in revenue cycle. I had thought from the beginning, and I think I'm going to be right about this. There is a mandatory negotiation period that we'll discuss later. Whereas the insurance carrier, if there's a dispute, remember before I was saying IDR is available. IDR is not available for ancillary services and emergency services, but it is available for out-of-network providers going to in-network facilities where there's a dispute. IDR is available. Before IDR, there is the first point here, negotiation requirement for 30 days from the initial payment. So what does that mean? From a practical standpoint, if there's a dispute with the insurance company is required, mandatory, to give you 30-day negotiation period, and they must open negotiations. If they fail to do that, you can file an insurance department complaint. This law applies to both self-funded and fully insured health plans. So in the past, if you filed an insurance complaint on a self-funded plan, the insurance department would say, well, I'm sorry, I can't handle this. I have no jurisdiction, go to the Department of Labor. In this scenario, they can't do that because this law applies to both federal and state governed plans. So what I found from a practical standpoint, and this is really bizarre, even the insurance carriers don't really know at this point in the regulation which bills are surprise bills and which ones are not. Which bills the patients have waived protections under the law and which ones they haven't. So what I'm finding is that I'm getting EOBs, and maybe you're getting these too, when I get an EOB, most recently from Aetna, Regions Blue Cross, some of the other Blue Crosses, they're referencing on the bottom of the EOB, and you need to look at the EOBs very carefully and tell your staff. If there's anything referencing No Surprise Bill Act, whether it's state or federal law, that's your cue that you can open up a negotiation with the carrier. Okay, so what I have been doing is I have been I've been having staff call the insurance company and in an intelligent way and say, hey, your EOB indicates that the federal surprise bill law is applicable to the processing of this claim. And you specifically say that we cannot bill the patient as a result. So if that's the case, you're required under the Federal Surprise Bill Act, No Surprise Act, to give us, to open a negotiation. And we have to have a negotiation period for 30 days. And after 30 days, within 4 business days at the end of that negotiation period, I can go to IDR. Okay, so I'm finding that I'm able to open negotiations. As a matter of fact, if you go on some of the carrier websites, like Aetna, for example, if you Google Aetna No Surprise Act, you'll see that they actually have what do they call it? They call it a open negotiation request form in PDF that you can fill out and you can send it either by fax or to federal NSA at Aetna.com and request that a negotiation be opened up. So if you're a revenue cycle person, I hope you'll agree with me, this is a really good thing, okay? The bad thing, which we'll discuss later, is that what is the rate gonna be, okay? And there's a lot of dispute about that. But I've been able to get negotiations opened up and get claims settled where the EOB talks about a surprise bill law, be it state or federal. And that's something that's really important that we need to take advantage of. All right, so you should be instructing your revenue cycle people, look at those EOBs carefully. It's usually at the bottom of the EOB on page 2 or 3. And if it says that, you need to open a negotiation. If they will not open a negotiation, you should file a complaint with Department of Insurance. Right now, because this law is so disjointed, there should be a federal dispute link for disputes that you can just link and open a negotiation. There is none. And there isn't really a complaint function at this point. We're being told in the EOBs to go to the Department of Insurance, but that's okay. So I like the part of this law that talks about mandatory negotiation. And I think that that's a real plus, and I'll mention it a little bit later, but we should take advantage of this provision. All right. And this is something that I'm sure the insurance companies will not want me to be talking about. All right. So under the law, you're entitled to IDR, but you're entitled to mandatory negotiation for 30 days. Get a supervisor on the phone. It's required. If it's Aetna or like Regents Blue Cross in Oregon, they have a dispute form you can fill out and start a dispute. So, I can show you, maybe if you email the organization or me, I can show you what that looks like. But in any event, so you have negotiation 30 days. Within 4 days at the end of the negotiation, you're entitled to IDR, and then you get to select the IDR entity. And again, if the EOB and the website for the carrier doesn't indicate how to open a negotiation or how to pursue IDR, they're supposed to, by the way, you need to call the carrier and be diligent. And if they will not provide, remember, a lot of times when you call the carrier, you're dealing with low-level people that most likely won't know anything about the No Surprise Act. You need to ask for a supervisor and demand that they give you what the law requires. And I'm telling you, even for cases that my clients all get disclosures, but even for those, I've been able to get negotiations, which is really bizarre because technically they're not surprise bills, right? But take advantage of what you have. The carriers play a lot of games with us. So, if we have something that's going to be very valuable to us, we should take advantage of it. So anyhow, these are the rest of the rules on IDR. You'll have this PowerPoint for reference. There are certain time periods for selection of an IDR entity. 10 days after the entity is selected, offers need to be submitted, decisions within 30 days, payment within 30 days. Okay. So the No Surprise Act requires providers, practices, and facilities to post and issue certain disclosures and notices. Now, here's a common question I get, right? And by the way, here's the notices. You have a balance bill, rights and protections disclosure, and a good faith estimate disclosure, but that's for uninsured and self-pay patients. All right. The posting is on a website and also in the office, right? So a lot of questions I get on these presentations are like this. I'm an out-of-network surgeon. I'm going to an in-network hospital. Okay. I'm a ancillary provider. I don't. Let's say I'm an anesthesiologist and I'm doing work at an in-network hospital. All right. So the patient can't waive protections under the act, right? So I don't have to get a consent because I'm an ancillary provider. Consent is not required because the patient can't consent. So do I still have to post? Do I still have to post a notice? Do I still have to provide a balance bill, rights and protection disclosure? The answer is absolutely yes. Yes, you have to. Okay, the rule makes it very clear that you have to do it. As a matter of fact, well, later on, if I can find it, I have a link to this, but I could read you the link. But the bottom line is yes, you have to provide the notice. So this is important. The disclosures are balance bill, rights and protection disclosure, and a good faith estimate. Now again, don't get crazy with these disclosures. Common sense, right? The purpose of the law again is to avoid surprise bills sending to the patient. So if you're going to get the patient to waive the protections under the Act by signing a consent that says that you're allowed to balance bill them, it has to be a clear-cut consent where the patient is acknowledging that you're out of network, that their cost share will likely be higher than if they went to an in-network practitioner, and they're voluntarily accepting this fact in writing and signing it. Okay, so the notices have to be posted in your waiting room and on the internet. Okay, so let's talk about the first notice, the balance bill rights and protections. If you go on the if you Google this, the CMS, you'll see that there are sample forms for this. There's a sample form for this, but basically the form that I'm looking at right now, right? This is common sense stuff. It says, I'm going to read right from the form as opposed to read from this, right? And again, it has to be on your website. That's the first bullet point. It has to be made publicly available, posting in your office, and it has to be provided upon scheduling an appointment or if the patient asks about it. Okay. So what does the notice say? It says, what is balance billing? Sometimes calls a surprise bill law. And it talks about what balance billing is, what out of network is, and what a surprise bill law is. The next thing the notice says is you are protected from balance billing for, and it provides what we already discussed, emergency services. Can't be balance billed for emergency services. It says it on the first page. By the way, this form has to be one page, but you can use front and back. Then it says certain services at in-network hospital or ambulatory surgery center, you can get balance billed for, and explains the exceptions. It also talks about ancillary services, right? And then it says that if you get a balance bill that violates these provisions, it shows where the patient can go. It gives links where the patient can go to complain, and there are links. I also like to put in the Surprise Bill Act for the particular state, be it Texas or Arizona. There's multiple states that have these laws. Okay, so again, disclosure, you need to put it on your website, right? And the disclosures are difficult for out-of-network providers because patients that read these disclosures many times will not want to go to an out-of-network provider because it'll scare them. No patient wants to get a surprise bill or a high bill, but this is the law, and this is what we have to deal with. Okay, the disclosure, again, limited to one sheet of paper, but it could be front and back. It has to be issued separately from other disclosures. It can't be, a lot of practices put all the disclosures on one disclosure form or one consent form. It has to be separate and distinct. Can't be linked with other forms. And to the extent it is posted on your website and included on the provider or facility website, it must be findable through public search engines. How they're going to enforce that, I have no idea. So that means, I would say, if you have a website, I'm sure it's available publicly. Someone can find your website. Just make sure it's posted prominently on the website. If a provider and a facility agree via a written agreement, and this is important. If you're a provider and you're going to an in-network hospital, my understanding is that many hospitals are actually undertaking the disclosure and notice requirement from the provider. So what they're doing is the provider and the facility or the hospital is entering into agreements. I'd be interested to know if anyone on this call has been getting these agreements from hospitals, but many of these hospitals are entering into agreements with their providers that are out of network, basically undertaking the obligation to provide this disclosure to the patient. So if you're an out-of-network provider doing out-of-network services at an in-network facility, be it a hospital or an ambulatory surgery center, I strongly recommend that you contact their legal department and get a contract where they undertake this responsibility. Now, does that mean you shouldn't post this on your website? I think it's a mistake not to post it on your website. Does that mean you don't post it in your office? I think you should post it prominently in your office. But it's nice to have the facility take on this responsibility. And the law specifically says if a provider and a facility agree via a written agreement that such facility will provide this disclosure in a manner and form required, then the provider will be deemed to have satisfied this requirement, but satisfied only this requirement, which is the rights and protections against surprise medical bills, the disclosure that's required under the law. Okay. This rule does not limit or change the requirement to post this disclosure at the provider's office or their website. I had just said that. Okay. Now, good faith estimates. How are we doing on time here? Okay, we're doing fine. Okay. This provision was supposed to be the consent and disclosure requirement, whereas the patient was going to sign a form to waive the protections under the Act. That consent form has a good faith estimate section to it. All right. I have one of the forms right here. Right. So if you Google OMB control number 0938-1401, you'll see a standard notice and consent document under the No Surprise Act. This document basically is a consent for the patient to sign, and you'll see on page 4 there is a surprise bill protection form, and then on the next page there's an estimate. A good faith estimate document where you're supposed to provide an estimate of all services, not just yours, right? And then the last page, there's a second to last page, there's a consent. The patient is signing that I'm giving up some consumer billing protection under federal law. I may have to pay full charges for the items or services, or may have to pay additional out-of-network cost share under my health plan by choosing an out-of-network provider over an in-network provider. I was giving written notice that explained my provider or facility isn't in my health plan network. That's the consent form we talked about prior to talking about this. That I got an estimated cost of each service and disclose what I may owe if I agree to be treated by out-of-network provider. I got the notice either on paper or electronically, consistent with my choice. I fully and completely understand that some or all of the amounts I pay might not count toward my health plan's deductible or out-of-pocket limit. Well, that's true. It only allowed amounts are going to apply toward the out-of-network deductible or out-of-pocket limit. Anything above the allowed amount, the difference between the charge and the allowed amount, which is the balance bill amount, is not going to be applying toward the patient's deductible out-of-pocket limitation. And then I can end this agreement by notifying the provider or facility in writing before getting the services, right? And then the last page is more about a cost estimate for all the services, all right? So what I'm being told is that the good faith estimate, there's no workflow for this right now. Hospitals, it's required that you're supposed to provide an estimate to the patient prior to service and after scheduling. You have to let the carrier know. The carrier has to provide an advanced EOB. The hospital has to provide expenses, a good faith estimate. It's a disaster. So they passed this law without really working out the details of how this is going to be, from a practical standpoint, how this is going to be applied. So it's a mess right now. So I've been told with good authority that the good faith estimate requirement is not going to be enforced until regulation and guidance is produced at the end of this year, and it may be effective in 2023. Who knows? So I wouldn't worry so much about the good faith estimate component, although the good faith estimate is still valid and enforceable for self-pay patients, those that have insurance that choose to have the service without insurance, and those that are truly uninsured. So the good faith estimate will apply for that scenario, but that's a minority scenario. Okay, so that being said, these sections are not entirely, well, I won't say they're not relevant, but it's not the most important thing to talk about because the enforcement is not going to be until, next year. So I'm going to go over these relatively quickly. I think the most important components of this presentation are the things that are in the interim final rule, the good faith, the consents, how a patient can legally waive the protections under the Act so that you can balance bill them legally without getting fined $10,000 per violation, and the posting requirements for the balance billing rights and responsibility, the topic we just discussed. So I'm going to go through this quickly, but these are basically how to satisfy the good faith estimate requirements. Again, there's going to be guidance on this, so I wouldn't worry about this, but you're supposed to post the good faith estimates requirement also in your office and on the website. Again, I don't think it's absolutely necessary right now if there's not going to be enforcement, especially since there's no guidance. So let's talk about the notice and consent requirement again. This is very important, and I want to make sure it's very clear. Okay, again, what is the purpose of the statute, the No Surprise Act, NSA? To avoid the situation where the patient gets a surprise medical bill when they're being treated by an out-of-network provider at an in-network facility. Doesn't apply to an out-of-network provider going to an out-of-network facility, because in that scenario, it's assumed that the patient understands what their risk is. It's not a surprise bill. But if the patient is going to an in-network facility with services being performed by an out-of-network practitioner, then in order to balance bill the patient, you have to provide the proper consent. So as a summary, if you're an emergency provider, emergency service provider, patient goes to the emergency room and you're out of network, you absolutely cannot balance bill the patient in that scenario. The patient is only responsible for in-network cost share. So when you're doing eligibility for those that truly are emergency care services providers, it's more important to check in-network cost share on eligibility than out-of-network cost share, right? Because that's what the patient's going to be responsible for, is the in-network cost share. All right, so emergency services, I think it's pretty clear. Can't balance bill the patient. You can go, if there's a dispute, you can go to arbitration, or you can demand mandatory negotiation, and 30 days later you can get IDR. Okay. Ancillary services, again, you have the emergency services practitioner, the anesthesiologist, the radiologist. Those are ancillary service providers. The consent, notice and consent form is not applicable because the patient cannot legally consent to waive the protections under the Act. So in that scenario, if you're an anesthesiologist, you cannot balance bill the patient. Patient is responsible only for in-network cost share. And if there's a dispute between the carrier and the insurance company, you can definitely go get mandatory negotiation for 30 days and IDR. Diagnostic services, that's ancillary. You should know at this point that's ancillary service providers. Cannot balance bill patients, all right? Obviously, if you're in network, this doesn't apply. Okay, so what happens in a scenario where you get the consent, the notice and consent signed, patient agrees to have services by an out-of-network provider, patient understands that they're going to be responsible for an additional cost share over and above their in-network cost share. Patient acknowledges they can be balance billed, but something happens in the surgery and some unforeseen medical need arises that requires the surgeon to take immediate action in order to protect the patient's life or prevent further harm. I don't have to tell you, common sense will tell you that you cannot balance bill the situation for those services, all right? Because the patient is under anesthesia and doesn't have the capacity to consent to those services. So even with a proper notice and consent, if the surgeon does something unique that's unforeseen, the patient can only be billed for those services at the in-network cost share, which makes it kind of convoluted, right? There are services that the patient consented to that hypothetically you can bill the patient, balance bill the patient for those services, but for the unforeseen services, you cannot balance bill the patient. Is that confusing? Absolutely. Does it make sense? Yeah, sort of makes sense. But you can see as I go through this law how confusing and complex these rules are. You know, and that's why enforcement is really not happening right now, because there's an understanding by the government, by the CMS, Department of Labor, Department of Treasury, who instituted the interim final rules, that they don't have their stuff together. So they haven't issued the proper guidelines. So therefore, they're not going to enforce. So that's a good thing. So anyhow, unforeseen medical services, you cannot balance bill the patient. It would be considered a surprise bill. Patient cannot consent to those. You're entitled to mandatory 30-day of negotiation and IDR. Keep in mind that you need to keep the notice and consent form that the patient signs that allows you to balance bill them for 7 years from the date of service. That may be different than your state law that may require you to save medical records, to store medical records for 6 years. So you should be aware, your providers need to be aware that you need to store the notice of consent for 7 years minimum. And, you know, if I were you, like I do, I keep it in my electronic medical record, or I store it on a server in a cloud. So it's always there. The point here is that it is very imperative that you follow the notice of consent requirements strictly. Otherwise, the patient can dispute its payment obligations to be balance billed. And I would recommend that you use the consents that are required by CMS, and take a look again at OMB control number 0938-1401. You can search that on the internet. All right, so you got to use the forms that are prescribed by CMS, and you have to follow these timely notice provisions. Okay, notice provision number 1, the consent, the notice of consent that you present to the patient has to be issued at least 72 hours prior to the date of service. At least 72 hours prior to the date of service. The notice must be issued at the time of the appointment is made, and no less than 3 hours prior to the date of service. The notice must be available, and this is typical government. The notice must be available in 15 of the most common languages in the geographic region of the facility. Go figure. I don't even know what the 15 most, I'm in New York, and I don't know what the 15 most common languages are in my geographic region. So again, what can I tell you about that? But so that's the provisions. Now, what does the notice have to include? A clear statement that the consent to receiving the service is optional. I did a webinar last week on this with Health Finance Management Association, and on the panel with 3 hospital legal department people. And apparently, if you're working at a hospital, they've already got these forms and notices ready to go, and they're also contracting with their out-of-network providers. So if you work regularly at a hospital, I would contact them, and they'll save you a lot of time in having to construct these notices yourself. They probably have a whole packet. They were talking about a provider packet that they have for their providers that are out of network, because they have an obligation as well. So I would contact them. But anyhow, the notice must be a clear statement that consent to receiving the services is optional. Again, this is all common sense stuff, right? Clear statement that the patient may seek care from an in-network provider. Well, of course, the patient has the right to see an in-network provider. That if they see an in-network provider, their cost share will be lower than if they go to an out-of-network provider, most likely. A notification that the provider is out of network, what it means to be out of network, that you don't have a contract with their managed care company, a good faith estimate of the amount the provider may charge, and notification that the estimate consent is not a contract. In other words, the patient is not bound to proceed if they don't like the estimate. Now, again, good faith estimate is part of the consent, but it's not being enforced, right? So I'm not personally too concerned with that requirement. If you can provide a good faith estimate up front, that's great. Keep in mind that with this advent of the good faith estimate requirement, it's going to really force a lot of out-of-network providers to reevaluate their charges, right? How do you give a good faith estimate to a patient that's in six-figure range? That patient is 99% of the patients out of 100 are going to go to an in-network provider and say thanks, but no thanks. So this is an opportunity to reevaluate your charges. A lot of the out-of-network, I work with almost exclusively out-of-network practices, and they tell me, and we do defensive audits, and then we do compliance, setting up programs like this. But I also own a billing company that does out-of-network revenue. So I'm telling you this for a reason, because I'm involved in all aspects: the legal part, the compliance part, the audit part. So it could, even myself, your head can spin sometimes, right? So, you have to be very careful to navigate these regulations, all right? And again, I would suggest you don't reinvent the wheel, especially if you work at a hospital. Call the hospital. They're preparing provider package for all of their out-of-network providers. They have an obligation to make sure that the patient, they don't want complaints either. If you're getting a violation for balance billing a patient that you shouldn't have, that either you didn't get the consent or you didn't get the proper consent, most likely a hospital will as well. Okay. You have to provide a list of in-network providers at the facility and notification that the patient can be referred to an in-network provider. Again, these notices many times will scare your patients away. So that's another reason why you might want to consider reevaluating your charges. I've seen some crazy charges in my time, as high as $1 million for surgeries. You shouldn't have charges that high, notwithstanding the fact that you may have to balance bill the patient, difference between charge and payments. It's a trigger for audit. So I highly recommend that with the advent of this law, that charges need to be reevaluated. Okay. You need to provide information about whether prior authorization or other limitations are required, whether a prior authorization was obtained. This is important stuff. Again, the purpose of the law, no surprise bills to the patients, right? Think about every time you read these regulations, think about the purpose. I know for me, it helps me understand better. The notice has to include a good faith estimate, right? We talked about this. These are the rules for the good faith estimate. Here's where I say that due to the disjointed implementation of the IFRs and the required mechanism, there is no real workflow so established at this point. So compliance is probably not possible. Enforcement is not possible at this point. Look at the first point, though. You're required to provide advance notice to the insurance company that the patient either waived the protections under the act or did not waive. Then the insurance company has to provide you an advanced EOB to you and the patient. How the heck that's going to happen, I have no idea. And we'll talk at the end of this presentation about the various lawsuits that are being filed right now. And this whole regulation or parts of it may be stricken ultimately, because some of these regulations, like the good faith estimate and the advanced EOB provision, are just almost impossible to advance, and that's why enforcement is really not being pushed at this time. Now, it should go without saying that notice alone is insufficient to satisfy the notice and consent exception. You need notice and consent. The patient must be given their formal and informed consent. In order for the consent to be valid, it must. Now, when you do your consents, whether you get it from the hospital or you get it online from the regulators, you can use this PowerPoint as kind of a checklist. And I think that, Amos did a good job putting this together, because now you'll have the PowerPoint, which you can use as kind of like a checklist, because there is no way that you're going to remember all these regulations. That's why I continue to point out to you, remember the purpose of the act, to avoid surprise medical bills being sent to the patient. Look at every issue and every question you have and compare it to the purpose of the act, and you'll probably get the answer without having to ask the question. That being said, we will have question and answer period within, I think I have another 13 minutes here. So you need consent. For the consent to be valid, it must be signed and dated clearly. Doesn't have to be notarized. It has to contain an acknowledgement that the patient was provided with the required notice, informed that the payment may not go toward their cost limitation. It won't go toward their in-network deductible, and anything above the allowed amount won't go to the out-of-network deductible or out-of-network maximum, outpatient maximum, and the out-of-network outpatient maximum. So out-of-pocket maximum, sorry. And it has to say that that they have an opportunity to receive the notice in a form selected. It could be by email, it could be on paper. You have to provide it to them in the format that they want it. Again, you're probably going to have it in your office posted as well. It'll also probably be on your website. Explain that the notice does not constitute a contractual arrangement. The departments here in the interim final rules, they want to make sure that the patient can understand that this is not a contract and that they have the right to go see an in-network provider. A lot of this is designed to steer patients away from out-of-network providers into in-network providers, which I'm not too happy about, but that's the reality. Again, I do think, though, that the mandatory negotiation period and the IDR component of this law could be very helpful to out-of-network providers. Time will tell, but so far it's been helpful to me. The provider facility must timely notify the plan or carrier as to whether, now here's the thing, how in the world is this going to happen? There is no criteria or guideline or link for this right now. I would think the carriers need to establish some sort of guideline with a link to notifying them prior to, within a certain amount of time after the service, on whether the protections of the act were waived by the patient. And you have to provide a signed copy of the written notice and consent document to the carrier. Again, crazy stuff, right? It's difficult enough to submit a claim. Half of the time the carriers claim they didn't get the claim, or submit an appeal, certified mail. I do a lot of appeals. Submit the appeal, certified mail. I have the certified receipt, or I send it by fax. I have the fax from them. They didn't get it. I'm sorry, you got to resubmit it. So this is a nightmare. The advanced COB too is a nightmare. So again, there's supposed to be some guideline at the end of the year. Just so you know, the interim final rule, I didn't mention this to you, it's over 500 pages long. It took me about 3 weeks to read the damn thing. Why the regulation needs to be 500 pages long, I have no idea. And yet it didn't cover some critical components that we're talking about now. Now, in a rare instance where an out-of-network provider is billing the patient directly, the provider or the facility may satisfy the above requirement of timely notification by including the notice with the bill sent to the individual. This is a rare situation. You don't generally send a CMS 1500 or UB form to the patient directly. You're billing the insurance company. So I mention it because it's in the statute. The next sections I'll cover real quick because we have about 9 minutes before question and answers, I think. Actually, I think we're starting questions and answers at 3:15. But I want to talk about the lawsuits that are being filed. So I want to kind of go through this rather quickly. You should know at the very least, and you'll have this PowerPoint, right, that the good faith estimate requirement is required for uninsured and those, when I say self-pay patient, I'm talking about a patient that has insurance but opts not to use it. So those two scenarios, you need to provide a good faith estimate. Now, I would think that you're going to provide a good faith estimate to that patient anyhow, but it has to be on the form prescribed by the government. All right. And the good faith estimate is supposed to be a consolidated estimate taking into account all services rendered for both primary, facility, anesthesia. It's onerous, folks. This is onerous. Again, not sure that this is going to be enforced at least till January 1st of 2023 and probably a lot longer. So that's why I don't want to spend a lot of time on this. There's a whole section on convening provider or facility, the party that receives the initial request for a good faith estimate and who would otherwise be responsible for scheduling the primary item service. That party is generally responsible to provide the good faith estimate. Folks, I don't know. I mean, I don't even know if I should really be going through this because it's very difficult. It's going to be very difficult to comply with this. How do you provide an estimate? If you're a surgeon, you have to provide, let's take a scenario. You're a surgeon and you're scheduling a procedure at a hospital 3 days from now. So that means you have to provide an estimate of your professional services. You have to provide an estimate of the hospital's facility charge or DRG, right? Then you have to provide an estimate of the anesthesiologist. You have to provide an estimate of the radiologist. You have to provide an estimate of the lab results and any other ancillary services. If you're looking this and you're hyperventilating at this point, you're not alone. So I have provided all of these slides for you so that you can understand this requirement. And again, try not to reinvent the wheel on this stuff. I'm just going to skip ahead here. Okay, I do want to spend about 10 minutes talking about litigation. Now, first thing first, we talked about mandatory negotiation, 30 days from the date of the EOB. All right. There are some carriers, like I said, that have outlined on their website procedures to institute this, like Aetna. Aetna, if you go to Aetna No Surprise Act, you'll see that they have an email address and a form that you can fill out to institute an arbitration and a negotiation. Okay, so you know, make sure you do your research and search that. Here's a I won't put who the patient is, but here's a something I'm doing for Regions Blue Cross. It's basically Regions Blue Cross they told us to go to their website, and on their website they have a provision that says that, just like Aetna, you know, how do you institute a pricing dispute? We're talking about negotiation, okay? So they said that you have to send, in this case, a dispute by fax to Regions Provider Disputes, Balanced Billing Rate Disputes, to this PO box in Idaho. And you have to call the letter an out-of-network pricing dispute, and then you have to indicate that you're an authorized representative of the member. So we have to include their out-of-network disclosure form. And then I usually put a paragraph explaining why I'm sending this, what the law is. And here I'm saying, as you're aware, the American Medical Association and American Hospital Association have enjoined the use by the, and we're going to talk about that, the Federal No Surprise Bill Arbitrator of a median in-network rate. So I'm letting them know about the second case here, the Texas case, that they're not supposed to provide a median in-network rate as the rate. And then what I do is I talk about the plan. And in this case, the plan, you know, I usually request a plan document and a plan booklet on every claim that my company bills, because on an out-of-network basis, that's the only way to really determine how the plan is supposed to allow. Verification of benefits are great, but the plan is better. So I usually request that. I have a summary plan description authorization that all my patients sign for my clients. And if anyone would like a copy of that, email me or the association and I will get you a copy. So in this instance, I actually have the plan, and the plan says that for out of network, the plan is reasonable charges, all right? And it actually could be 40% of bill charges under the plan. And I cite the page number 94 of the plan. And then I go into the CPT codes, right? I go into the CPT codes here, right? And I say that, I compare the allowed amount to the Medicare rate. And in this case, they're allowing at about 140% of Medicare, 150% of Medicare. And I'm like, this is hardly reasonable and customary. And, it says that reasonable charges can be 40% of charges. And that's what we want here because of complexity. And then I attach a letter of medical necessity from my doc, my surgeon. So he, advising that she advised that this was a 4-hour surgery and it was very complex. And so I'm asking for 40% of charges. They allowed it at $1,600. I'm asking for $4,800.80. And then I'm asking them to respond within 30 days as required by the Federal No Surprise Act. I started doing this, and every time I get an EOB that talks about No Surprise Act, I go online, research this. If there's no information, I have my reps call, find out, demand to speak to a supervisor, open negotiation. A lot of times they'll just send it to via Multiplan, Global Claims, or Data Eyesight. But in this instance with Regions, they said, well, we can't do that. You have to request by fax a pricing dispute. By the way, doesn't it annoy you that you have to send appeals either to a PO box or by fax? Many of my appeals are 150 pages. I have interns from college working for me, and they've actually told me, what's a fax? In college, nobody uses faxes. These young kids don't know what a fax is. And I said, well, welcome to the world of insurance, where they put a million obstacles to reimbursement that you have to jump through in order to get a claim paid. And one of them is we have to send 100-page faxes for appeals. Whereas you can send claims electronically, but you have to send an appeal by fax or to a PO box. Why do they do that? I believe they do it to avoid paying claims. They could tell you, oh, I didn't get your appeal. Whereas if they gave you an email address, you can provide proof that they got it, and it's as easy as pushing a button. But no, we have to send a 150-page fax. So anyhow, I do a presentation on out-of-network workflow. We talk a lot about those kind of things, and it's just these are the things that drive me nuts. Doing revenue cycle, and I'm sure they drive you nuts as well. Or if you're out of network, how Blue Cross won't talk to you even if you have a designated authorized representative form. Drives me nuts. Anyhow, so let's talk about these laws. I have about 10 minutes to talk about it. All right. So one of the biggest problems with the interim final rule is that unlike the regulation, the statute that was passed, the CMS, Department of Treasury, Department of Labor decided to take it upon themselves to determine what rate is presumed to be correct when there's a dispute between a carrier and an out-of-network provider. So what rate do you think they actually came out with? This was pushed by, I'm sure, insurance company lobbyists, right? The median in-network rate. So under the interim final rule, it says if there's a dispute between the provider and the carrier, the arbitrator for the IDR must consider the median in-network rate as presumptively the correct rate. And then they said that you can fight that, but that's presumptively the rate. Well, you can only imagine people like myself went ballistic. There's a couple problems with that. One is that none of my clients have access to what the median in-network rate is. They're out of network. Where are we getting this rate from? Well, the rate is coming from, guess who? The carrier. So now it's almost like we have to accept the carrier's rate. Carrier says the median in-network rate based on our database is $100, and the Medicare rate is $1,000, and the reasonable customary rate is $3,500. We have to accept $100. That's presumptively correct. Now we have to overcome the presumption. Good luck with that. It's crazy. Crazy, 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 right? So that's what they decided. So thankfully, thank God, the American Medical Association and some other out-of-network providers, and also the Texas Medical Association, which, by the way, Texas Medical Association usually takes point on a lot of these type of issues. They filed lawsuits against the U.S. Department of Health and Human Services, Department of Treasury, Department of Labor, and said, "Hey guys, now if you read the lawsuit, it doesn't necessarily say this, but this is what I get from it. This is what I glean. Hey guys and gals, the statute doesn't say that a rate for a dispute is the median in-network rate, and that it's supposed to be presumed. Where are you getting this from? You're making it up, and you got it from the carriers. And your job is to create regulation so that payers and providers can comply with this statute that was passed by Congress. You can't change the law. You can't change the statute. That you've overstepped your boundaries. So that's where these lawsuits were filed. As soon as it came out, I called the AMA and I spoke to whoever I could speak to and say, hey, if we don't overturn this, every provider out there is going to be in network. That's what's basically this law, the interim final rule made every provider essentially in network provider. And the rates, we have to assume that the rates provided by the carrier are going to be the presumptive rates. We don't even have access. In fact, there are some carriers, there are some third-party administrators that do negotiations like Zealous. They're advertising right now that they have the median in-network rate, right? And I called and I said, well, I'd love to get that. And they said, well, no, you represent payers, providers. It's only for the payers. So this is crazy stuff, right? So these lawsuits were filed. Okay, so this is basically what they're basically saying. Both lawsuits are basically saying, hey, you can't just invent what a qualified payment amount, which is what the law refers to, the rate if there's a dispute. You can't just say that it's not reasonable and customary, that it's presumptively the median in-network rate. That's not fair. You're changing the law. You can't say that. So both these cases are in litigation, but thankfully, there was a ruling on February 23rd, 2022, which was a big victory for us, the providers. And the U.S. District Court for the Eastern District of Texas ruled in favor of the Texas Medical Association, striking a critical blow to the department's interpretation of the No Surprise Act. They basically said they struck that part of the law. The qualified payment amount is not a median in-network rate. So now the question is, what is that rate? Under the statute, it's not supposed to be a Medicare rate. That's good for us, but it's not reasonable and customary either. So what is it? I have no idea. So I'm going to argue it should be the rate that's set forth in a plan, like I did on my Regents price dispute appeal that I did. I said the plan allows at a reasonable rate. It could be as high as 40% of charges based on complexity. Here's a letter of medical necessity. It shows that this is a very complex 4-hour procedure. I want 40% of charges. I think that's a reasonable argument, all right? But thank God I'm not, the argument on the flip side can't be it's a median in-network rate. Can't be, because it was stricken down. Now, the CMS published an advisory, and they said, I put more information here if you're interested about what the ruling says. You can also search it online. But CMS says they're evaluating whether the ruling, and they're going to determine whether or not they're going to appeal it. So they haven't decided it. But here's the interesting part: if you look up the carrier websites, Aetna, I think I looked up United Healthcare and some of the others, they don't talk about this. Surprisingly, they don't talk about this ruling that's against them. They're still talking about the qualified payment amount as a median in-network rate. If you look it up, you'll see what I mean. I was shocked to see that. You'd think they would have had a little caveat there and said, well, Texas, the federal district court ruled that the qualified payment amount as a median in-network rate was stricken. No, they didn't say that. So, I guess I shouldn't be surprised by that. But I frankly was a little surprised by that. So, all right, so that's that. And let me talk about some of the other lawsuits, right? I had a friend of mine, even though I get LexisNexis and I get these lawsuits emailed to me, a friend of mine sent a provider showed me what the Medical Society of New York is doing, and they filed a lawsuit against Empire Blue Cross in New York. Now, here's what when this was passed about the qualified payment amount being in a median in-network rate, a lot of my clients called me up and says, oh my God, now the insurance companies are going to go back and they're going to say, oh, on the nice plans like Empire United Healthcare in New York allows at 80% fair health. They're a good reimbursing plan, right? My clients were concerned that they're gonna undercut all of the out-of-network claims now at a median in-network rate because they're going to get their authority from this interim final rule. Now, the argument here is you can't do that. You can't change the contract that was agreed to by the member and the insurance company. And in the case of Empire United Healthcare Empire, it's a fair health rate at 80 percentile it's a reasonable and customary rate for out-of-network in New York for state workers. You can't just start allowing an in-network rate on those claims. Well, that's exactly what the lawsuit alleged that United Healthcare is doing. So a lot of it, I told my clients, I said, nah, that's not going to happen. They can't change the plan documents. The plan is the plan. And under ERISA, the plan rules. So they're not going to do that. Well, they did it. So the interesting thing about this is that I was able to pull the lawsuit, and the providers are being represented by a firm called Garfunkel and Wild, who frankly did a very, very nice job in this lawsuit. Now, it hasn't been decided yet, but I have a letter dated March 15th to the governor of the state of New York where they outlined their grievance. And I think it's very, very well done. They talk about that United has dramatically slashed reimbursement to out-of-network providers, puts Empire Plan members at a serious risk of losing the very benefit their unions bargained for: broad access to doctors of their choosing across the state at reasonable cost to the members. Put simply, United's drastically reduced reimbursement rate for the out-of-network physicians creates an enormous disincentive for the physicians to continue to treat Empire Plan members, and the result will be that Empire Plan members will no longer have access to as many physicians. This is not speculation. We represent and have spoken to groups of out-of-network physicians, and they provide backup for this. That is awesome. I'd be happy to share this March 15th letter. They also sent a letter to the regulators, which I thought was also well done. They sent a letter to Deputy Counsel to the Governor, Executive Chamber for the State Capitol. I thought that was well done as well. And also to the Department of Financial Services that governs the insurance law. So that's interesting. And I'm happy to see it. I thought that this should have happened before the interim rules, right? But apparently the interim rules blew everybody away and they could not believe what happened. So then finally everybody started taking a look at this. There's also been other lawsuits filed. Where is it? There is 7 other lawsuits that have been filed. Bear with me one second. Can't seem to find it. But anyhow, the point there is that it is not just New York that's taking the bull by the horns. It is other states are now doing the same thing. And some of the lawsuits don't just attack the qualified payment amount. They attack the whole arbitration process. They call it unconstitutional. Now, if we were having this presentation to lawyers like myself, we would talk about the law and the various nuances of the law. I don't think the audience wants to hear that, frankly, but suffices to say that it's not just the qualified payment amount being attacked. And so I think that it's very encouraging. There also was a couple months ago, we're going to start questions in a couple minutes, A couple of months ago, there was a bipartisan letter. If you could imagine, bipartisan, that never happens, right? There was a bipartisan letter issued by about 150 legislators to the government departments complaining about the interim final rule as well. And I think that's a good sign. So where does that leave us? And then let's just talk about where that leaves us. Well, you need to do, like I said before, you need to look at the EOBs. Any EOB that talks about federal surprise bill law or either state or federal level, you need to call the carrier. If the EOB, look at the EOB, it may tell you what to do. Like the Texas ones tell you to go to the Department of Insurance. But I would research this on the carrier website, call the carrier, speak to a supervisor, demand 30 days mandatory negotiation, get your negotiation, hopefully it gets sent out to a third-party negotiator like a Global Claims or a Viant, Multiplan, Mars, Data Eyesight. If not, they need to tell you who's going to be negotiating this, and then take advantage of the independent review, the arbitration process, and make sure you any response to either the negotiation or to the IDR that talks about a median in-network rate, you need to slap that down and make sure they know that the Texas federal district court ruled that the that the qualified payment amount is not an independent median rate. It's not that it can't be a median in-network rate. It's just that it can't be presumptively that. So in other words, it could be something else as well. What it's going to be, I don't know. Like I said, I haven't gone to IDR yet. Every time I filed or asked for negotiation, I've been able to negotiate it. And again, many of the negotiations are done on claims where we have the consent, and yet they offered negotiation anyhow. This is not being not truthful to the carriers. They don't ask me if it's a surprise bill or not. If they ask me if it's a surprise bill or not, I would tell them it's not a surprise bill, and then I wouldn't be able to get mandatory negotiation and IDR if we can't settle the case. But they're not asking that question, which is quite bizarre. You would think that that would be the first thing they would ask, but they're not. So I'm just saying, hey, I got this EOB. It says federal surprise bill law. I want my mandatory negotiation, 30 days required by the law, and they're giving it to me. Okay, so I'm going to end it here, and I'm going to open it up for, this is my contact if anyone wants to get a hold of me, or you can go right through the association, Amos, they've been great. And I know that a lot of people don't feel comfortable asking questions. So, I'd be happy within the next 24 to 40 hours, I'd be happy to answer any question that's not answered, because I know we only have about another 16 minutes or so. So I'm going to open it up right now. I see a couple questions here already. I have one question. I don't know if I'm allowed to say their names, but the first name is Sarah. Is it necessary to provide disclosure to every patient that walks in the door, or only those who are out of network? Well, you're not going to provide the disclosure to in-network. All right. If it's in-network, you don't have to provide the disclosure. If they're going to be out of network, then you have to provide the disclosure, even if the out-of-network service is going to be at an out-of-network ambulatory surgery center. You have to provide this. So the answer is yes, you have to provide the disclosure, but not to in-network patients. Okay. Oh, also not to Medicare, TRICARE, or any government payers. Not to workers' comp or PIP or no fault either. Okay. Next question. For those of us that are in private practice or private group practice, and we only do oral surgery in our own office, how does this apply? Do we sign consents and financial agreements in advance? If you're going to bill out-of-network services, then you have to provide the required consents. Again, even though you're doing oral surgery in your office, okay, the question there is the surgery you're performing is the office in or out of network? If it's in network, you certainly do. But again, before I was talking about take a look at this. I pulled the actual regulation because a lot of this type of scenario, if the consent provisions don't apply, why do I have to post a notice? Why do I have to do all these other things? Well, I didn't write the law, but it's required. It says here in the statute, and I'm quoting, each healthcare provider and healthcare facility shall make publicly available a one-page notice in clear and understandable language containing information on the following: requirements and prohibitions of such provider or facility. So in other words, it's the requirements that we talked about that have to be in a notice. Any other applicable state law requirements, you have to provide that notice. And information on contracting with appropriate state and federal agencies in the case that the individual believes the provider or facility violated any requirements. The only way you can get around those requirements is to enter into a written agreement with the facility that they're going to provide all the disclosure and the consents for you. And I would have an attorney take a look at that. And if they're going to take on that responsibility, if you're working at a hospital, they really should. Then I think you need to contact their legal department and try to get the what they call the provider, out-of-network provider packet, and have an attorney look at it. And then the good faith estimate for uninsured and self-pay patients. It says that you're required to inform all uninsured self-pay patients of the availability of a good faith estimate of expected charges upon scheduling an item, service, or upon request with the information that we discussed. So unfortunately, my position is that you have to provide that notice, even if you're performing services in your own office. You don't want to be subject to the $10,000 penalty. Now, are there exceptions and nuances? Yes, and it's difficult to answer a question like this without knowing more details. I hope that answers. Next question by Chelsea. Hypothetically, see a patient in the office. They are informed that the provider is out of network. The provider determines that for whatever reason, patient would benefit from having surgery in a hospital versus the office. And the hospital is in the patient's network. Is this case, is the NSA consent mandatory? Yeah, you're out of network. I'm assuming you're out of network going to an in-network hospital. So yes, the requirement would be necessary. Remember, it's not just notice, it's notice and written consent. Michael asks, our office already has patients sign that we are out of network and they pay, I'm sorry, Michael here. Our office already has patients sign that they are out of network and they pay full fee at the time of service. Then we send for the insurance carrier to reimburse the patient directly. Can you do that within the law? When the patients pay you up front, they're giving you a down payment toward their co-insurance deductible. There's nothing wrong with you collecting that money up front. Now, it might be required that you have to provide that information as to the payment on your claim form when you submit it. That I can't comment on. I'm not sure about that. But whether they pay money up front in full, in part, or not at all doesn't really change the requirements. If you're an out-of-network provider performing services at an in-network facility, you have to get notice and consent signed by the patient in order for the patient to be billed anything more than an in-network cost share. Now, if you don't get that consent, then you can only bill the patient their in-network cost share. Don't confuse the consent and notice requirement with the other requirements to post balance bill notices on the website and in your office. That's separate, and that's something you have to do anyhow. Okay, so collecting money up front or collecting part up front or collecting nothing up front really doesn't change this scenario. If you want to, if they're collecting money up front, they're paying their service in full, and you need to provide them. Common sense tells you that you need to provide them the notice that they can see an in-network provider and not pay up front. I mean, that's kind of what the law is designed to do, right? Casey asks, Can you elaborate more on if there are no in-network providers in the area, what bargaining power we have with the insurance companies? As oral and maxillofacial surgeons, there are very few in our area, most accept limited insurance. Do we need to obtain the in-network providers from the facility or the insurance company? Example, local hospital does not have an in-network provider, but insurance company covers another facility and provider in the area. Well, the fact that they have very few in-network providers is a good thing, right? I can tell you that I can tell you what I do. I have a lot of clients that we do medical billing for that are unique, and they're the only provider maybe in the West Coast, for example, that does what they do, right? Most of the plans have a provision called the in-network gap exception provision, where it says that if there are no in-network providers within 50 miles, then the carrier has to offer you a what's called a gap exception, where they're going to offer you in-network rates as a one-time shot deal. And when we get an in-network gap exception, all of the carriers except for United offer us a rate agreement. And it's not uncommon to get 70–80% of charges. So if that's a scenario, you might be able to get an in-network gap exception at the pre-auth. You have to get the pre-auth first, and then you have to ask them, how do I get a pre-auth gap exception? And once you get that, how do I get a rate agreement? So, I hope that answers the question. But I mean, I think it's a good thing for you if there are no in-network providers that do this. You can simply put in your notice that there's no in-network providers that we're aware of that do this kind of service within 50 miles. So I think that could be a good thing for you. Allison says, we are an out of network with all medical insurance companies, and we have only one doctor in our office. So we would be considered out of network. Would patients coming for wisdom tooth removal have to have these documents signed if they want us to submit to medical? Well, like I said, if you're doing the service at an out-of-network facility, so that means you're doing the wisdom tooth removal at your office. If your office is out of network, then the notice and consent requirements wouldn't be required because you're an out-of-network surgeon doing a procedure at an out-of-network facility, which is your office. So the notice and consent forms would not have to be filled out. The other posting and notice requirements would have to you'd still have to have the posting on your website about out-of-network and balanced billing requirements and the No Surprise Act law. And you'd have to be able to provide the patient a copy of that at time of scheduling, all the rules we discussed. But the notice and consent requirements are only available, they only apply for elective surgeries done by an out-of-network provider at an in-network facility. The scenario you're talking about, which most of you deal with, about doing a surgery in the office, frankly, that's not the thing that this law is really concerned about. They're really concerned mostly about the situation where you're going to an in-network ambulatory surgery center or hospital. That's the most concerning. I don't think the enforcement people are really going to take a quick look at you. Are going to look. You're not going to be a higher priority than a hospital. Put it that way. All right, but you have a notice and consent requirement, which is different than your requirement to post your balance bill notice requirement, and your requirement to give the notice to the patient at time of scheduling. So those are all different. But if you're out of network and the office is out of network, you wouldn't have to provide the notice and consent. Lucas asks, does the NSA law apply to medically billed charges only, or does it include charges billed to dental carriers, such as wisdom teeth and extractions? So you're asking if we're billing to a dental carrier. Well, I read the law which says each healthcare provider and healthcare facility shall make publicly available a one-page notice. Clear, understandable language given to the patient at time of scheduling and posted on their website. It doesn't say with the exclusion of dental offices. So, you know, I would say that there is no exception for that. I would, though, as a caveat, I don't deal much with dental insurance. I do deal with surgeons that are oral surgeons that are billing surgery procedures to medical policies. That I deal with. So I think you should check with the Dental Society or with the Amos might be able to help you as well on that issue. But I don't see an exception for dental offices. I don't. Katie asked, does the good faith requirement apply only if over 400? Yes. I didn't mention that. Yes. Or is it for any amount? Do they have to get a good faith estimate prior to consultation or examination? It only applies to over 400, and I believe the law is you have to provide it at time of scheduling. I don't know the exact law. I'd have to look it up again, but I think it's at time of scheduling. It's in the PowerPoint, no more than 3 days prior to, and if the scheduling occurred less than 3 days, it has to be within a certain time period before. There's time periods that are in the PowerPoint. But yes, good point, over 400. All right, again, the good faith estimate is probably not, it's probably not gonna affect, it's probably not gonna be enforced until 2023, so I wouldn't get too crazy with that. When asked, we are out-of-network providers who perform jaw surgery, authorization approved by insurance at an in-network hospital. We submit claims as a courtesy for our patients and now receive payments from insurance. However, insurance does not want to cancel payment and will not submit payment to patient directly. Not sure where the question is there, but if you're an out-of-network provider performing jaw surgery at an in-network hospital, you are not an ancillary provider. You're not an emergency service provider. You would have to provide the notice and consent to the patient in order to balance bill them. Otherwise, you would have to bill the patient their in-network cost share. You would still, and any dispute with the carrier, you could get mandatory 30-day negotiation, and you can get IDR if you can't negotiate. So that's the general rule. This is different than the requirement to post a balance bill requirement. Where is that? So the requirement about you have to provide your rights and protections against surprise bill laws, medical bills, that it's going to be, that outlines what a surprise bill law is, what balance billing is, exceptions for emergency services and ancillary, that they can use an in-network provider, that if they feel that they're being billed for something that, you know, where they can go and file a complaint, that still has to be posted on the website and has to be provided to the patient prior to the service. It seems that this is only for services in a facility, not my office. Joseph asked that. Well, we just talked about that in the last question. If it's not just for facility, if you're an out-of-network provider performing services in your office that's out of network, right? I'm assuming you're billing it global or something like that. Then you wouldn't have to provide the notice and consent. But if the person providing the service is out of network and you're actually, you know, the office that you're doing this, the place of service is in network, then the notice and consent would apply. So I would think if you're out of network and the office is out of network and you're doing the service at an out of network office, then yes, the notice and consent requirement wouldn't apply. The rights and protections against surprise bill that you're posting on the website and all the other requirements that you have to post are still available, you know, something you have to do. Christopher asked, what if you are in network with the patient's dental, but out of network with medical? But if you're billing, again, obviously the notice and consent would not apply for your in-network service. But if you're out of network with medical, if you're an in-network provider performing services at an out-of-network facility, I'm sorry, an out-of-network provider performing services at an in-network facility, then you would have to provide the notice and consent and have the patients get the notice and sign a consent in order for you to balance bill the patient. So that would still apply. Is there a one-page template available? There is searchable online. I'll see if I can provide it to you guys, but I'll talk to Amos about that. But you know, I got these right off online. I also gave you the I don't know if you caught the OMG citation I gave you earlier. OMB control number 0938-1401. If you pull that, that's a Health and Human Services consent form with a good faith estimate. That'll be really helpful to you. Dana asked, and just from a time check, we only have a couple. I can take maybe a couple more questions, if that's okay. And then any other questions you have, I'll be happy to answer by email. Because I think we're over time already. Dana asks, doctors out of network with Medicare, but provide services at an in-network hospital. Medicare doesn't apply. If it's Medicare, the surprise bill law does not apply. Can we bill patient for the services? Absolutely. Medicare is exempted. Medicare, TRICARE, government plans, and no fault, PIP, workers' comp. You don't have to provide notice and consent for those. They're exempted from the law. The No Surprise Act doesn't apply to them. So yeah, you can still bill them and do a contractual write-off. I'll take one more question. Jaram asks, on-call providers, we are obligated to provide a cost estimate prior to any treatment to patients we visit in the hospital on an emergency basis. If yes, no, if it's an emergency basis, you don't have to provide a good faith estimate. You don't have to provide a notice and consent. It's not necessary. Remember, the notice and consent is only applicable for, it's not applicable for emergency services or ancillary providers like anesthesiologists. If you're doing an elective out-of-network service at an in-network facility, then the notice of consent is applicable if you want to bill the patient more than the in-network cost share, if you want to balance bill the patient. All right, and remember, because I think there's a little confusion here, look at the slide that deals with this provision. Don't confuse notice and consent with this notice that's required, okay? This is the one page front and back that you have to provide to the patient. You have to post it. And again, if you do work at a hospital, call the hospital up, get them to sign a written agreement that they're gonna take care of the disclosures for you. I'm over in time. I think it's better off for us to end at this point. And I can answer, I see that there's a lot more questions. I can literally be doing this for the next hour. So I'd be happy to answer all of these by email later on today or tomorrow, if that's okay. So I'm going to turn it back over to Joe.
Thank you so much. This concludes today's program. This webinar has been approved for 1.5 hours of continuing education. A certificate of continuing education will be available upon completion of a course evaluation and assessment. To claim your certificate of continuing education, please return to the program page. If your office requires additional CE certifications, please email a list of participants and the original registrants' names to ceonline@aaoms.org. On behalf of the American Association of Oral and Maxillofacial Surgeons, I would like to thank you for your participation in today's event. Thank you and have a great day.